Aaron, thank you so much, and thank you for having us as part of this session today. We have the somewhat interesting task of rounding out today by talking about the division and characterization of assets that we all know exist, but maybe we don't spend enough time studying to feel confident that we know exactly how to divide the assets. And so we're joined today by Jared Tonks, who is a forensic accountant that probably many of you know, and Greta Schulz, who maybe some of you don't know, but she is a litigator who specializes in IP law. So we're going to be talking today first about issues with intellectual property. Jared, do you have the ability to share our slides so that we can use that as kind of our guide for today's presentation?
I believe I do. Let me pull that right up.
Thanks. And while we get while Jared gets started with the slides, Greta, do you want to kind of by way of getting us started and kicking us off here, introduce yourself to the Beverly Hills Bar Association's Family Law Division, who may not know you, and get us started talking about some of these assets that we characterize as intellectual property that we may be less familiar with in terms of characterization and division issues.
Sure. Thank you, Greg. Yeah, as Greg said, I am a litigator. I specialize in intellectual property and commercial litigation, and I do no family law whatsoever. So in the realm of family law, I may need your help here a little bit, but I was asked to speak on uncommon assets that are sometimes divided at divorce. And I have a lot of familiarity with these assets, even outside of family law, because intellectual property is valued for many different reasons, rather, when you're doing merger and acquisitions, during litigation, when you're trying to determine damages. So I have some experience in valuation of IP, and I'm hoping I can help you guys identify the IP, and we can discuss ways that it's valued.
Yeah, so I think you all can see on my screen now, if I'm correct. Greg and Greta, can you see the screen?
Looks like we're good to go, Jared.
Yes, I think we're good. Yeah.
Okay, sounds good. So we're going to talk about these not so uncommon assets. I know that everyone is probably seeing more and more of these type of assets in the divorces that they're doing. I know I'm seeing them more and more every day. So it's important to be able to understand these types of assets and be able to speak to your clients intelligently about these assets. And so our goal today is to help introduce you to these assets and be able to speak intelligently with your clients when these assets arise and determine whether or not you need maybe some expert help with these assets. So the assets that we're going to be talking about today is cryptocurrency, non-fungible tokens, peer-to-peer non-traditional banking, and of course, intellectual property. And I'm going to leave that one to Greta since she's the expert here.
Yeah, I'm going to go over the main types, the most common types of intellectual property that I think you're going to find when going through the marital dissolution process, and ways to identify them, and then sort of little nuances and tips and tricks on valuation. And that's trademark, copyright, patents, and trade secrets. There's a right of publicity aspect. I don't know, I'll touch on it a little bit, but it's not really gonna, I don't imagine it's going to come into play in terms of division wise, because right of publicity is someone's own name, image, and likeness. It is a type of IP, but I think the four main ones that we're going to touch on, I think, are most important to you guys are going to be trademarks, copyrights, and trade secrets.
Okay. Perfect. Jared, do you want to start us off by talking about the non-IP assets that we're going to be dealing with today?
Certainly. So, want to start off by defining the assets. Let's start off with cryptocurrency. Now, cryptocurrency, everyone's heard about it. You've all seen images like I show you on my screen here of what I guess some artist imagines what a Bitcoin would look like if it were a physical asset. Now, there is no such thing as a physical Bitcoin. It's not something that you can hold in your hand. It is literally just a chain of code, computer code. And it's based on this blockchain technology that it can work as a form of currency. So once again, we all see these images, but there is no actual physical coins out there. The good benefits to blockchain technology and cryptocurrencies, it's nearly impossible to counterfeit. So you can't go out and print more of it because it doesn't exist but for the computer code. Ultimately, a lot of people like this type of currency because it's not government backed. But it comes with some risk because of that lack of government backing. Now, the important thing that you all need to know, and this is probably the greatest misconception with cryptocurrency, is it is perfectly traceable. Every single transaction can be easily searched with a quick computer search. It's like a Google search, but you have to go to certain websites in order to search the actual blockchain. But you can put in a transaction ID into that search engine, and you can see exactly where the money came from and where the money went to. And so once again, although the transactions are anonymous, there's an address with every transaction, just like the address to your home. And if you know who lives at the home, then you know where the money came from and you know where the money went to. The question is making sure that you know the address where you need to look. And once you know that address, you should be able to trace these transactions, but for some very nefarious activities with crypto mixers or tumblers, most of this is perfectly traceable. The next thing that I want to bring your attention to is called non-fungible tokens. Now, the easiest way that I describe non-fungible tokens is like a title to your home. Okay, a title is a piece of paper. It represents ownership in your home, but it's not actually your home. That is the same exact thing as a non-fungible token. The difference is that it uses this computer code, once again, a computer code that's perfectly traceable, but it helps you identify ownership to either a real world asset like a home. It could replace titles, physical titles to a home. It could replace that, or a digital asset of some kind. Maybe you created an image for a computer game. You could show that you have ownership of that image from a non-fungible token. There's a lot of real world applications to non-fungible tokens. I mean, NFTs could be used to replace tickets to a sporting event. You just have to remember that for each NFT, they are unique. It's like you with your fingerprints, okay? Everyone is different, and that's why it's non-fungible. But once again, these are becoming more and more commonplace, and it's important to realize when you find out and you're talking to your client and they say, oh, listen, husband or wife, they're involved in these NFT things. I don't know what it is, but I know that they're involved with it, that you start to ask the right questions.
So Jared, can I start with maybe asking what might be one of the right questions? As I hear your description, is the NFT itself doesn't have the value. It is what the NFT is the title to. In other words, the title to my house as a 8.5 by 11 piece of paper has no value. It's that it conveys title to a piece of real property that has the value. Does the analogy hold that the NFT itself has no value? It just gives us information about the underlying asset that has the value.
And that's a difficult question to answer, Greg, but in most cases, yes, you're exactly correct. So for example, in the sporting ticket world analysis, right? You have a ticket. Once the ticket has passed, it's really was only worth whatever it cost to get admission to that event for that seating location, right? Now, after that event has passed, the ticket's still there. Someone probably has it. And if there's a collector's value to the ticket, then there may be value as well. So consider it that way. There are NFTs out there, which, you'll typically see images of some digital artwork that is associated with it. And some of these NFTs, people have programmed them so that they seem to reproduce. So you got, if you Google out there, cat NFTs, apparently these NFTs are programmed so that way you have two cats, they have offspring, they'll have offspring, and people are trading these cat NFTs. It's pretty crazy. But let's keep it really simple and just back down to that sporting event scenario where imagine that ticket, right? The real value is getting admission into the sporting event. And yes, there may be some collector value after the fact. Okay, so let's see here. I have a question. Let's go ahead and read that. It says, husband and wife who speaks only Spanish takes English language and acting lessons. Let's see here. I'm not sure this one relates to our presentation, so I'm going to pass on that. So we'll continue on here. So the next type of asset that I want to talk about is peer-to-peer transactions, or what I'll refer to as non-traditional banking. In this example, we can talk about Venmo, PayPal, Zelle, Google Pay, Apple Pay, Meta Pay. Meta is Facebook. So you can even pay people through Facebook. So the question is when we're doing these divorce engagements, are we asking our clients about these type of accounts? And the reason that this is important is because when you come and you're starting to look into an account, let me give you an example. So I had a doctor that developed prosthesis. They're called prosthetists. And essentially this doctor would allow his patients to do their copay with PayPal. Okay, now the PayPal account was never reported on a tax return. It never, those payments that came from patients to him to his PayPal account were never reported on his tax return. He never deposited funds from the PayPal into his business bank account. And so the only way that we knew about the PayPal account was wife, being extremely diligent, said, listen, I know when I walk into his office, he's got a sign advertising that patients can pay with PayPal. Let's make sure and ask for those statements and information. And so we got a download transaction history from PayPal, subpoenaed that information, and lo and behold, there was hundreds of thousands of dollars in client copayments or patient copayments held within PayPal. And so once again, these balances can be held outside of a traditional bank account. And it's important that we start to ask questions. Do you have any Venmo, PayPal, Zelle accounts? I know that my wife loves Venmo because when people pay her or reimburse her, she puts a restaurant charge on the credit card and then our friends will reimburse us with Venmo. Well, that's her play money because Jared doesn't need to know about it, right? Because she can take that Venmo money and she can do whatever she wants with it. And it's fine. I really don't care. But once again, you have to understand that there's easy ways to monetize and use these funds. It's important to note, though, that it's not FDIC insured. So people with large balances, if one of these applications goes underwater, that entire balance is at risk. So there's no government agency coming in to back that up. but it's made payments between friends really easy.
Well, Jared, is there any, this feels like the Wild West. Are there any changes coming with regard to these types of accounts that might start to make them more traditional and make our lives easier in terms of finding them and accessing them?
I mean the good news is a lot of the time with a Venmo, most people have linked it to a traditional bank account. And so we'll see the transactions coming to and from a traditional bank account from Venmo. And so once you see the traditional bank account and you see those transactions, you can start to ask that question. But you're right, it is somewhat the wild, wild west. When we go back to my example of the prostitutes that accepted payments via PayPal and chose never to report that, now there is requirements by the government to report those type of transactions. In fact, in one of our later slides going on down the line, everyone that receives payments more than $600 is going to receive a 1099. And that includes all of you. So for example, if I have I'm going on a family vacation, I go and I book the Airbnb, it's $5,000. And then, I have my family members reimburse me and they each send me $1,000. Well, all of a sudden I'm going to get a 1099 this year if they send it to me via Venmo. And so that's another change that's coming. So we're likely going to start to see these type of accounts on an individual's tax return.
Does that, will that, then that gets reported on the tax return. So it sounds like this concern of the doctor who can stash hundreds of thousands of dollars in some PayPal account, that's going to become harder and harder to do because there'll be some tax reporting on it.
Yeah, exactly. And what the government is trying to do, the IRS is trying to do, is to crack down on gig workers, the hairstylist, the small-time tax accountant that was receiving payments via Venmo or Zelle or PayPal, and they just never reported that information to the government. So that's really what the government's trying to do, is crack down on those individuals that are not reporting revenue. And it seems like that's going to happen. Before, you had to have over $20,000 in payments, or it was some crazy amount of transactions per year. So now they're really raining down on that. The bad news is for the average person that's going on a family vacation, you're now going to have to report that information on your tax return, and then you're going to have to report to the IRS that, guess what, it was just a reimbursement, it wasn't actually income. I don't know exactly all the details about how that's going to show up on our 2022 tax returns, but I know it's coming.
All right. Over to Greta.
Yeah, and I don't think we have, I think we have a finalized one up, but I'm going to go ahead and talk about intellectual property and ways to identify it as an asset during the marital dissolution process. Intellectual property is kind of a unique beast in the sense that it's an intangible asset. Their ownership rights, essentially. And the way that they are divided isn't like, the way you would, I assume, look at the money in an account and you get 50 and I get 50. It's more of a valuation process. And there's some intellectual property that's more direct. And I say direct because it's more easily identifiable. And then there are others that are more indirect. And I'll go ahead and start with the more direct intellectual property. It's going to be things like patent and copyright. So, and the reason I say they're direct is because, you can have a patent, which is an invention. You can have that without it being related to a business. You can have a copyright without it being related to a business. So to kind of give you an idea, again, patents are, think of inventions, think of products, Usually there's some functionality to a patent. There are utility patents. There are also design patents. They don't have functionality. It's sort of an ornamental design. They are a little bit more unique, not as strong, but just when you think of patents, think of an invention. An example would be like a medical device or computer software, something, again, that somebody invents. And in order to get a patent, you have to apply for one. And you do that through the USPTO, it's United States Patent and Trademark Office. And when you apply for a patent, you can do a provisional patent, which gives you a year to kind of test out the claims and figure out what you want to do with it. But once you actually have a non-provisional patent, you only have 20 years to own the patent rights. And after that, it's extinguished. So patents are very limited in that sense. The other one that I said is another more direct example would be copyright. And this copyrights are works of authorship. And some examples of a copyright would be if your partner wrote a book or a spouse wrote a book or created a song or a painting or a movie, something to that effect. And once that copyright is created, copyrights exist at the moment of creation, that author has exclusive rights in the publishing, reproducing of that particular work and any derivative of that work. And so copyright's interesting because copyright does exist at the minute you create it. So if, the spouse writes a book, doesn't necessarily need to register it with the Copyright Office. However, in order to, let's say somebody infringes on somebody's copyright claim, so somebody reproduces the book, plagiarizes it, something to that effect, you're going to need a copyright registration in order to enforce any sort of, to sue on that, any sort of lawsuit, and eventually any sort of judgment or settlement. The less and what I call indirect types of intellectual property, so the less obvious ones, are going to be things like trademark and trade secrets. And I say they're less obvious in a sense that they're usually connected just by virtue of what they are. They're usually connected to a business. And so things like, for instance, I'll start with trademark. To identify a trademark, it's typically either a word mark, so a name or word, or a logo, so it can be a symbol, or a combination of the two. But it's like branding. It's very similar to branding, and so it's like that logo or that name being used in commerce in connection with a good. And you can't just, unlike patent, right? Patent, you can apply for a patent, own a patent, and never use it. But still, if somebody else tries to copy it, and this is what patent trolls do, they apply for a patent, they don't use it, someone tries to copy it, then they go sue them. The difference between patents and trademark rights is with a trademark, you always have to be using it. And so that's why I say it's typically connected to a business. And it's typically valued with the business. And when you think of trademark, think of McDonald's, like the golden arches, or the name McDonald's, or the Nike swoosh, or the name Nike. When you apply for a trademark, you do that through the United States Patent and Trademark Office as well. And those rights will allow you to prevent others from using confusingly similar marks. Trademarks can be forever as long as you're using them. You do have to renew them every 10 years, which funnily enough comes up a lot. People will get a trademark and then forget to renew it, and then it lapses, and then that turns into a whole other thing that's probably a different conversation. But as long as you continue to renew your trademarks and continue to use that branding, in connection with a good or service, you'll have a trademark.
So Greta, you told us that patents last for 20 years and 1 year with a provisional patent. You told us that trademarks can last forever. Copyright, how long does that last?
So it's life of the author plus 70 years.
Okay.
And just so you know, these, and I'm sure this comes up a lot and is very important in family law, these types of IP, they can be co-owned. They can be owned by one spouse or the other, but they can be co-owned and they are transferable. Intellectual property rights are transferable as well. The one other category of trademarks that, or rather intellectual property that I want to touch on is a little bit more obscure, and it's trade secrets. And trade secrets are anything that is proprietary to a business that derives some sort of commercial value. And so, and the main sticking point with trade secrets is it needs to remain a secret. So you're not going to have it out there registered with, you know, any sort of government body. It's going to be something that is, like I said, just proprietary to your company and kept in secret. And some examples of things like these are like methods, processes, KFC's fried chicken recipe, or Dr. Pepper's, you know, secret formula for why it tastes the way it does. Those kinds of things can be considered trade secrets. And like I said, these are just by the very nature of their being are usually, they have to be included in a business because you can't have this separate from a business. So those are the four main categories.
So now that we kind of know what the intellectual property is, I'm sure all of the family lawyers are thinking, okay, so now we find out there's a patent or a trademark or a copyrighted material or trade secret. What do we do about, and now the couple's getting divorced. So now what do we do? So I guess what we'll do is we'll kind of bounce back and forth. So we got Jared talked about the assets. Now we'll talk about valuing them. Greta talked about the intellectual property, and we'll do valuing intellectual property next. So Jared, let's kick it back over to you to talk about valuing these assets that you brought to our attention.
Certainly, and it just real quick, Greta, trade secrets, those can last forever, correct?
Correct. As long as you have it's the same thing with trademark. You know, as long as you have the business and you're keeping it in secret and it still derives commercial value, sure.
Perfect. So real quick on valuing the cryptocurrency, this is all public information. It's just like a stock price. You can go out there and you can Google right now. If you're at home on your computer or at the office, just Google what a Bitcoin's worth. Just say value of Bitcoin, put that in your Google search, and guess what? You're going to see exactly what that is worth in US dollars. Once again, we're still US based. US dollars still is the standard currency here. And so there's people that value these things instantly based off of the value of the US dollar. And that the same applies with the other versions of cryptocurrency as well. You know, if you get an ETH, you know, you can look that up too. You know, it's all out there. The important thing to remember is that it's constantly changing. It's not like the New York Stock Exchange that closes when the bell rings. You go out there at midnight, and then 2 minutes later, it's going to have a different value. And that's because the market never actually closes. So once again, it's information that's out there. You know, I had a cryptocurrency tracing case where I put a value as of 5 o'clock on a specific day because I knew that, you know, 30 seconds later it was going to change. And then I pulled that information, used that in our balance sheet, and everybody has to know at what point in time you're valuing those assets.
Jared, the answer is $21,326 as of about 30 seconds ago.
There you go.
I have a question about Bitcoin specifically and cryptocurrency generally. Are these assets divisible? In other words, if I have one Bitcoin, can I give someone half of my Bitcoin, or do I have to maintain one Bitcoin as a unit?
That's a great question, Greg. And fortunately, with Bitcoin, now it's different on each individual cryptocurrency, but Bitcoin can be divisible up to a very, very, very small fraction. And I say very 3 times on purpose because I don't know what the answer is, but if you go out there and you can look, you can get down to basically $1 worth of Bitcoin. And when it's worth $20,000, that's 1/20,000th of a Bitcoin, right? So ultimately, it is divisible in kind, and that may be a good option if your client thinks that the value is going to go up. Cryptocurrency has been very volatile as of late, and so it's important to consider whether you should divide that in kind or consider a buyout in something a little bit more stable like the US dollar.
And can I ask another question about cryptocurrency? When we talk about cryptocurrency as an asset, do we calculate gains and losses, and are there capital gains and losses on cryptocurrency the way there would be on, let's say, a stock?
There absolutely is, and it's calculated the exact same way that a stock is. And in fact, on every single individual's tax returns, there's a box that you have to check whether you participated in cryptocurrency transactions throughout the year. It's on the front page of the tax return, right up near the top. And so the government is very conscientious of the gains that people have experienced trading cryptocurrency or investing in cryptocurrency or conspiring in cryptocurrency, whatever term you want to use. There a lot of people out there doing it. And so there are gains and losses. And when you buy or sell the cryptocurrency, it is a taxable event and it's subject to capital gains tax.
And when you talked about being able to trace these things on the blockchain, will it show us the cost basis of the asset in the blockchain so that it's pretty easy to figure out the cost basis in the asset?
It will not.
No.
And that's important to know, and your clients should be aware of. It has to be tracked separately. Now, there are apps and software that is trying to catch up with the cryptocurrency, but it's moving so fast. Coinly is the one that comes to my mind. And that's where you can download the transactions from the blockchain. You can use the transaction IDs. It will actually upload into Coinly, and it will calculate your cost basis if you track it. The studious cryptocurrency investors are going to be using some sort of application or software in order to track that. Everybody else might be tagged with 100% gain on those assets when they're sold if you don't know what your cost basis is. NFTs, once again, these are the underlying asset needs to be valued, whether that's digital or say it represents title to a house or a piece of artwork. And I forgot to mention on NFTs are great for artwork because you can trace provenance. You don't have to worry about whether the art has been stolen if you're using this code from the time that the artwork was first sold throughout the transaction, because we will know exactly every step of the way where that piece of art how it was sold, where it came from, the original artist. There's a lot of great benefits with NFTs. Now, and the peer-to-peer transactions is just like a bank account. If you work here in the US and you access that account, it's going to be in US dollars. So it's just like a bank account.
So now we get to kind of start to synthesize things, because now we're going to talk about the assets Greta taught us about, and Jared, you can start talking to us about how we value it. So let's, Greta, do you have an asset in mind that would be best to talk about different approaches to valuing?
I think probably the easiest and most direct one is, a book, maybe a husband authors a book, something like that. Because again, it's not really commingled with the business. And I think that's, probably the best.
All right. So Jared, my client wrote a book. Let's say he started writing the book prior to marriage. and started writing it 2 years prior to marriage, and then finished it 3 years into the marriage. And now, after a 5-year marriage, the parties are separating. And so we have 2 years of pre-marital effort, 3 years of marital effort, 2 years of benefit, selling the book or whatever, and now we're separating. Can you talk to us about the ways that you might go about valuing the community's interest in that book?
Certainly. And there's several different ways to approach this. The most common approach is a time rule formula, where you basically look at it and you say, okay, you were working on the book 2 years prior to marriage, and then you have 3 years during the marriage. Based on that math, we would assume that 40% of the book was separate property. And so we could use a time rule formula to apportion that. Now, I suppose whoever authored the book would argue, well, it was my idea long before the marriage, and you all have legal cases out there for one way or another. But I think if you're going to apportion it, a time rule formula seems logical in order to apportion the book between community and separate property, and of course valuing that book. I mean, of course, if it never sold, you're probably not going to have a lot of value there. But of course, if you are selling that book, you can look at the income approach and see what income is generated from the book sales. And you can do a buyout for the value of that asset, or you could have some sort of interest so that every time the book is sold, 40% goes to the separatizer, the remaining 60% is community. And so therefore, the out spouse would receive about 30% of the book sales.
But Jared, talk to me about practically how this works. So there's a book, and we know that in the first year it was a New York Times bestseller, and it sold $3 million. It made $3 million of income for the author. And the next year it kind of started to wane a little bit. The next year was $1 million. And now I come to you and I say, okay, what's the community owns 60% of this book. How are you going to figure out what a buyout number looks like on a asset that has waning value? But who knows, one day it might get turned into a movie or something like that and have some huge additional stream of revenue. What's the thought process you're going through in trying to come up with a buyout number?
I mean, and Greta can speak to this as well, but most of these intellectual property assets are diminishing in returns. I mean, over time, they're going to gradually become less and less valuable, unless you're able to keep that trade secret completely secret, for a very, very long time. But ultimately, you have to look at if the out spouse wants a buyout. The easiest is a carried interest where you retain, and every time you get that check in the mail, you just divide it proportionally based off of the sales data. Otherwise, if you can't do that and you're looking at a buyout, you have to start looking at forecasting the future income from that book and really trying to determine what's going to happen into the future. Now, ultimately, if you think that a movie is going to be made in the future, a carried interest might be best.
Then we have if we continue down the slide, you posed a question of should the intellectual property be valued separate from the business? And so let's talk about that for a minute, because I think what Greta has taught us is that the business can own the intellectual property, but for some companies, the intellectual property may be the key asset. A patent may be the key asset of the business. And so do you want to start walking us through your thought process about whether or not we just value the business as an entity, or do we parse out the intellectual property and start going through and having basically 2 lines on the balance sheet for the company and then subcategory the intellectual property of the company?
Certainly. So, for example, the trade secret, let's go back to Dr. Pepper. or let's assume Coke. I don't know which soda manufacturer owns Dr. Pepper, if it's its own thing, but let's
I
assume
think
Coke.
it's Dr. Pepper, actually.
Is it Dr. Pepper?
It might
All right.
be. Yeah.
So if we're
If Dr.
valuing,
Pepper were getting divorced from Mrs. Pepper,
if Dr. Pepper were getting divorced, that trade secret is within the business. So what is the value of that trade secret? Well, the value is the cash flow that it generates. And so, you know, under an income approach, it's very easy to value that. Would you break that out separately from a business? Absolutely not, because that is what drives the business value. So it's inherent within the business. Now, for example, and Greta can talk to this more, but say somebody comes in and steals Dr. Pepper's secret recipe. They take that recipe and they go and use it and they profit off of that recipe. Well, now all of a sudden, how are damages calculated? And damages are calculated based off of several different methods. Well, what if I license my recipe out to somebody else? And we can see that Coke did that, right? They licensed it out in Mexico to somebody else to produce it. What type of royalty were they paid, right? That's a market approach. And then, or let's look at the cost. What would it take to recreate the Dr. Pepper recipe if we were doing thousands of iterations of soda? And I can't imagine a more mind-numbing work of tasting all these different sodas, trying to make it better, right? But if we were to do that, how much would it cost? So there's all these different approaches to valuing the intellectual property. But Greta, you shared a instance with me in a family law case that you were working on where there was some infringement, and one of the spouses wanted their slice of the infringement after the marital settlement agreement. Share that story with us.
Yeah, no, there's a case. It's actually it's called In Re Marriage of Worthy, and it's just it's one of these cases where there's an instance of, you know, a husband writes a book, and at divorce they agreed to split the royalties, and that was what was agreed upon. But what happened years later after the dissolution is then the husband finds out that somebody infringed on the intellectual property, so on the book, and then goes and sues, I forget the name of whoever, but Mr. Infringer. And then the wife wants a piece of the pie when he files the lawsuit. So what happened in that instance is it was more of an analysis, because what happened is the intellectual property suit got thrown out. There was no infringement, but the analysis was interesting, because the wife wanting to take monies from the intellectual property after the divorce is an interesting analysis, because it's kind of contrary, right, to family law, right? Like after you get divorced, isn't everything supposed to be separate property?
So good question. And for the family lawyers out there, a lot of them are probably screaming at the screen, 2556, because we have family code section 2556 about, I hope I got that code section right, about omitted assets. And so what happens oftentimes in a divorce is parties will not account for an asset. Oftentimes kind of the quintessential one is a retirement account, and they'll just forget 30 years ago, oh yeah, I had some little pension at this company I worked for 5 years or something, and we just totally overlook the pension. And so the court has continuing jurisdiction over an omitted asset forever. If someone brings to the attention of the court, we just never mention this asset in the judgment, court can divide it even years and years and years after the divorce judgment is done. But the scenario you're suggesting, we assign to one spouse the intellectual property, perhaps the book, but assign to the non-creating spouse a portion of the revenue stream.
Right.
If it's specifically royalties, that's what gets assigned to the non-creating spouse. And so I think we then are in a world where we're parsing the judgment to see if that lawsuit is in fact an omitted asset that the parties never contemplated or divided between themselves, or does the terms of the judgment give the right to that lawsuit to the creative spouse, because all that the non-creative spouse created, or is entitled to rather, is a portion of the royalty or residual stream. And so a cautionary tale, I guess, there, when we're drafting our judgments, to be very, very clear about what are we granting to each of the parties, because I can imagine a carefully worded marital settlement agreement that addresses the issue. But I can imagine many of our marital settlement agreements that don't address the issue and leave it for future litigation and creative argument. So that's kind of where my mind goes when I hear about the hypothetical.
Yeah, and that's exactly sort of what the analysis is, because at the end of the day, like for instance, the book, the copyright itself, created during the marriage, the, you know, however you guys refer, the blood, sweat, and tears that went into it was during the marriage. It's not, you know, there's no post-marital effort after the fact, although there was some argument that, you know, having to file the lawsuit, but at the end of the day, the actual asset, there was no post-marital effort. And so, yeah, you're right. I mean, I think it's an important thing for people to think about when you are distributing those assets, to really like think of all sorts of situations that could occur, and especially with intellectual property. I mean, that is the bulk of the value of intellectual property, because it's a right? So the bulk of it is this passive value that it has, to be able to, you know, use it defensively, because there's, you know, the active value, right, is actually putting it out there in commerce and selling it or branding. But the passive value can be immense, right? Especially when you're talking about, you know, patents, right? You have a patent infringer, you have a patent troll. Oh, I just wrote this patent, I'm going to hold on to it. I didn't really do anything else with it, but I have an infringer now, or maybe several infringers, and you file several lawsuits. I mean, you're talking potentially millions of dollars of passive value for that one set of intellectual property, that one asset. So you have to be wary of those things. It's really important to think about the passive value of it.
Completely agree.
Sure, John.
Yeah, so moving on, you know, we've talked about the taxes somewhat throughout the presentation, but just a note in your materials, you can see that capital gains tax applies to the cryptocurrency, the NFTs, and if the intellectual property as a whole is sold. So say you have a patented asset and you sell the patent, and you transfer that patent to a new company, that's booked as a capital gains. Now, if you allow another company to manufacture that patented asset, and they pay you a royalty for each unit that is sold, that's known as a royalty, and that's subject to ordinary income tax. So just—
And is that the same as licensing? If I take my intellectual property and license someone else to use it and they pay me for it,
that's ordinary income, as opposed to selling the asset as a whole. And lastly, you know, we talked about the 1099s that are coming for the peer-to-peer transactions.
So I can talk a little bit. So we've learned a lot about these assets, but now we get down to the nitty-gritty of what happens when we have to divide them up. So there's nothing shocking here. These are well-known methodologies to the family law community, but we can divide in kind if the asset is susceptible to that. A Bitcoin being the kind of asset that we talked about is obviously dividable in kind, valued and charged to one party. What we do with most businesses, we can do with royalty streams and residual streams and other intellectual property, or just have a carried interest where we continue to own it in some form of joint ownership, and each party continues to get some revenue from that asset. So nothing too novel on that slide.
Greg, can we get a carried interest in court, or is that typically something that we would see more in a settlement scenario?
So so it's a great question. I think that the technical answer is yes, the court can allow for carried interest. The court, if the court makes sufficient findings that the asset cannot be adequately valued, cannot be adequately divided, that the only way to ensure that the community is properly compensated, then I believe that the court can, under certain circumstances, grant a carried interest. But my experience is that the court will be very loath to do that. The court is looking for clean splits. And so if the court can just value the asset, even if the court knows that the value it's putting on the asset is inevitably wrong, because we don't know what the future revenue that's generated from the asset is going to be. But if there is sufficient evidence that the court can put some value on it, my experience tells me the court would much, much rather take that route than having two people who are, in your hypothetical, at trial in front of a court and saying, I'm going to force the two of you to continue owning some asset jointly. That is disfavor.
I see.
So then we talk about, you get the case in the door, you understand that there's some asset in this case that's less familiar to us than a house or a retirement account or stock portfolio. What are we doing? What are some best tips and advice? And then suppose we have to, we get all the way to the point where this case is not settling, the issues are not resolving, we are going to trial. What do we do? What are some tips and tricks when we are confronted with this situation? One tip I have, one pointer I have, is get the experts in early. We know from just an hour of this presentation how much wealth of knowledge someone like Jared or Greta can share with us. Bring these experts in early. You're going to avoid a lot of wasted effort, a lot of wasted time, if the experts can help us prepare for resolution sooner rather than later. That being said, any expert won't do. I cited here Evidence Code Section 720 about what a expert needs, and they have to have special knowledge, skill, experience, training, or education to qualify them as an expert. If we're not in court, you can rely on anybody you want for anything, but in court, that's what you need to be able to show in order to qualify someone as an expert. So, well, Jared is brilliant. No one can be an expert on all of the different esoteric assets that we might confront. So identifying an expert early on and making sure that you're probing that expert. Do you have expertise in the specific assets that are here? Do I think that I can qualify this person as an expert if we come to trial? It's easy to think, well, it's a case, there's some money involved, I'm going to retain a forensic accountant and let the forensic accountant go to work. But unless that forensic accountant can qualify as an expert as to some of the assets, we wouldn't say, well, there's a house, so I'll just have Jared opine as to the equity in the house. Well, he can't value a house. That's outside of the purview of his expertise. Similarly, with some of these other assets, let's bring in experts who can give the court reliable information about the specific asset. The other thing is, when we have these esoteric assets, let's know our judicial officers, because some of them may be very up to speed on these assets. You don't need an expert to come in and explain what an NFT is. Others may require more background. And so through pretrial motions, through status conferences, things like that, as you're trying to figure out how you're going to present your case at the time of trial, I would be having discussions with the judicial officer about, I've listed these experts. This expert is going to provide background information to the court about such and such a topic, and let the judicial officer say, you know what, I think we can probably cut that testimony. That may not be useful to the court. So start working and thinking early on about how you're going to educate the trier of fact on these issues. Then I have my final slide is on negotiating settlements. So when we have these assets, I have my four bullet points here. First, disclose. We know what our fiduciary duties are, the fiduciary duties are of our clients. But when we have these assets, you have to work with your clients. They may not be intentionally hiding it. They may just forget. They may not think about it. You need to be probing the client when you're doing the preliminary declaration of disclosure, when you're answering the discovery, to make sure that you're disclosing it. Because if you're the doctor who, oops, just forgot that he had a PayPal account with 400 grand in it, a trier of fact may not find that that was an innocent mistake. And I could imagine a scenario where that doctor's disgorging 100% of his PayPal account to his spouse. So disclose. When I do these deals, especially if I have the out spouse, but sometimes even if I have the in spouse, I'll negotiate a tail for a liquidity event. We talked about the idea of a book getting turned into a movie. Well, sometimes what I'll negotiate is if there's a liquidity event related to a piece of intellectual property, within 2 years, 3 years, the court retains jurisdiction to revisit the valuation that we assigned to the asset, because we're all guessing as to the true value of the asset because we don't know what the future revenue is actually going to be. So if we can retain jurisdiction for some limited period of time, if there's a liquidity event, now we know what the value of the asset is, the book that was written completely during the marriage, and we all know it's community property. Well, if we retain some tail on it, then maybe we can come back and get more precision. And that's obviously good if you're the out spouse, but it can be good if you're the in spouse, because you give some comfort to the other spouse who says, no, I think this thing is going to be worth $1 million or $10 million. Well, okay, I don't think it will, so I'll give it to you at some lower value. But if you're right, there's a tail on there. One thing I like to do, again, when I have the out spouse, is request representations and warranties. I warrant that there are no patents associated with this company. I warrant that there are that the trademark has expired. I warrant and represent and warrant these things so that if there is some misstatement, there probably is a remedy, some set aside remedy or breach of fiduciary duty remedy or something, because what we don't know is oftentimes intimidating. So asking for reps and warranties is something that I think we don't do a lot in family law, but can be really useful in cases like this. And then a final thing is oftentimes when I'm dividing these assets and putting a value on them, I'm explaining how I did it in the judgment or in the marital settlement agreement. I'm explaining the methodology we used to get there, so that if someone ever has to come back years later and look at what was someone dishonest, was someone cheated, whatever was going on, there's a roadmap. If all we say is that the trademark is assigned to wife and she shall pay an equalization payment of $1 million, or worse, the trademark is assigned to wife and then 8 paragraphs later, the total equalization payment for the house, the retirement accounts, the cars, and the trademark is $2 million. We have no idea how anyone came up with the value of the trademark, or if it was valued at all, because all we have is one lump equalization payment. So explaining the methodology in the marital settlement agreement, I think, can make sense. And nothing stops us from saying we have difference of opinion. Wife thinks that it should be valued this way and has this value. Husband thinks it should be valued this way and has this value. But for purposes of compromise, we agree that the value of this asset is so-and-so, and that's reflected in the equalization payment below. I just think you avoid a ton of litigation in the future if you kind of show your work at the outset. So those are my tips and tricks as we move toward the end of our hour together.
Well, thank you guys so much. That was very informative. My brain hurts a little bit because I don't do math, which is why we have Jared and Greta. But I wanted to thank you so much for participating today and being part of our symposium. And did anyone else want to say a last word?
I'd just say our emails are all in the slides. So if you have any questions, we didn't get to all the questions that came in during the presentation, just ran out of time. So feel free to reach out to all 3 of us. We're more than happy to answer those questions.
Yeah, I just want to echo Jared's comment. If there's anybody that has any questions regarding intellectual property, whether it's identifying it, valuing it, just wants to have a discussion, feel free to reach out. My email's up there. You can call my office.
Well, thank you so much, and I hope everyone has a great rest of their weekend.
Great, thank you.
Thanks. That is it for today, everyone. Have a great weekend, and thanks for tuning in.